of contract presented by Let's Succeed Education. These are a series of short lectures to enable a student to gain a sound understanding of what a contract actually is in English, or what is often known as common law. That includes the nature, role and purpose of commercial contracts. So this is the introduction series of lectures. Lecture 1, which is this one, which is what is a contract, followed by Lecture 2, how a contract is formed. Lecture 3 concerns offers, and further lectures will follow. So, Lecture 1, what is a contract? A useful short definition of a contract is a promise or set of promises, and most importantly, which the law will enforce. So the fundamental of this is the agreement must be legally binding, so enforceable in a court of law. However, every contract is an agreement, but every agreement is not necessarily a contract. For example, an agreement between a husband and wife, maybe to pay a certain amount of money on a certain point in time for a specific action. Well, the courts presume there is no intention to be legally bound in that sort of agreement, unless they are given evidence to the contrary. Therefore, we have an agreement, but in fact that is not a contract. And there are 4 basic elements that must be present to have a valid contract. So the 4 essential elements are: there must be an agreement between the parties. There must be intention by the parties to be legally bound, in other words, enforceable in a court of law. There must be certainty as to the agreement's terms. They mustn't be vague and imprecise. And, most importantly, in English law, there must be consideration. There must be some value in the agreement to all the parties to the agreement, no matter how small. Now, it is value to the parties to the agreement, not necessarily to outsiders. And even if all of the 4 illustrated above are present, there are other factors that can result in the contract being legally unenforceable or even void from the start. So an unenforceable contract, unenforceable by the courts, is valid, but the courts will not enforce it. A void contract is no contract at all, a nullity from the start, so it doesn't exist from the very beginning. So the following are examples of factors that may make a contract that's seemingly valid unenforceable and in some cases void. So first of all, we have contrary to public policy, a contract for an illegal purpose. This would be probably void from the start. So, for example, a contract to commit a crime or defraud the Inland Revenue, for instance, are contrary to public policy and illegal, and therefore void from the start. One party is under duress. Therefore, there is some threat of violence if they don't enter into the contract. So they're not entering into it under their own free will. Next, we have one party has been misled, a misrepresentation. So a representation is a fact that may induce one party to enter into the contract. However, a misrepresentation is something that is false. So one party is misled into the contract by a false statement of fact. For example, they are told the car they are about to buy is a genuine Porsche, when in fact it's actually a kit car and is a copy, and therefore is not genuine. Lack of capacity. All natural persons can enter into contracts, except if they have a lack of capacity. So a lack of legal capacity. So they're under legal age, they're certified insane, or they're declared bankrupt and are not discharged. Those are just examples. Then we have, there is a fundamental mistake. For instance, unknown to the parties, the goods that form part of the agreement have actually been destroyed. That makes the contract void by mistake. The next short lecture will be lecture 2, how a contract is formed, and this will include the forms of a contract, the very basic terms of a contract, which we dealt with in much more detail at a later date, and some detailed requirements to have a valid contract. This lecture 1, What is a Contract?, was presented by Let's Succeed Education.